All right, it's the time to get started. Bills Committee on Insurance Companies Amendment Bill 2013 is the 13th meeting. Before we start, it's still the Chinese New Year, so I wish you a very happy New Year and a very prosperous year ahead. If you don't smoke, then the premium that you have to pay will be a lot lower. If you can quit smoking, then your premium will be a lot lower. All right, thank you. Item 1, follow-up to issues arising from previous meeting. The administration has provided a paper on its response to issues raised at the meeting held on the 9th of February 2015, paper number CB-1 593/14-15-02. Shall we invite the administration to walk us through the paper? Yes, thank you, Chairman. In fact, last time, many issues raised were related to the inspection and investigation of the records and also the policy intentions of those. So we have now provided a paper to set out the details. Item 1 is about the new section 41B(6). It says that the IIA may in writing appoint a person or a person belonging to a class of persons to conduct routine inspections. And last time, it was asked why we need to have this category of a person belonging to a class of persons. In fact, sometimes the IIA might need to assign a group of employees within the IIA to conduct the investigation, and therefore there is no need to specify that. So that's an administrative arrangement to facilitate the work of the authority. And that drafting method is also used in the AMLO. Under 41D1, it's also said that with the consent of the FS, the IIA can appoint one or more other persons to investigate specific cases. And once again, we'd like to explain that similar arrangements are also available under the SFO as well as the AMLO. And we will look at the experience gained so far to see if we are able to streamline the process and further amendments might be necessary. Next is about the costs incurred by investigators. Well, for general investigations, the IIA should be able to fund that out of its own expenses. But then we can also foresee that in special circumstances where complicated cases have to be investigated, we may have to engage overseas experts, and in the circumstances we may need to get additional funding from the LegCo. So in the circumstance, we might need to invoke 41D(2) to get the funding. From para 6 to 8, when we refer to investigators, why we say that investigators will have to produce a copy of the direction or appointment before he can start the investigation, while routine inspectors do not need to do the same. In fact, the policy intention is that, well, for routine inspections, they are routine in nature, and therefore, when you make a call, when you try to obtain some papers, sometimes it's just for the purpose of a routine inspection, and if you have to produce documentary proof, it might be a little too cumbersome. That's why we believe that in terms of the drafting, there is some difference between investigation and inspection, and where the person is required to produce documentary proof, he should do so as soon as possible. As far as investigation is concerned, as there is already preliminary information which satisfies the IIA that there is a reasonable ground for suspicion, that's why the IIA will have to investigate the case. That's why we also believe that the investigation might need the insurer to face disciplinary action. That's why in the circumstances before any investigation takes place, the investigator will have to produce a copy of the direction or appointment. That's the intention. Also, on the FS power to initiate investigations, we have taken a look at the AMLO, the BO, the Mandatory Provident Fund Schemes Ordinance, and also the Financial Reporting Council Ordinance. All these ordinances do not give the FS the power to initiate an investigation. Only under the SFO, in very special circumstances, that's under sections 356 and 357, where powers were given to the FS to look into cases involving the disclosure of ownership or of interest in listed corporations, and then he can appoint inspectors to investigate into these issues. And the context of this is very different from the context of investigating a licensee of the regulator and also the intermediaries. And IIA is an independent market regulator, and therefore, in terms of the regulatory powers of the IIA, it should be able to act on its own. That's why we do not think that the FS should have the power to initiate an investigation. Last but not least, at the meeting held on the 12th of January, mention was made about a new requirement that for insurers' appointments of controllers and directors, they would require the IIA's approval. And if there is no such approval from the IIA, and if the insurer continues to appoint such controllers or directors, then he would be found guilty, and there would be a fine. And for the controllers or directors would also be personally liable, and there would also be a daily fine. And members also asked how come the insurer would not have to pay the daily fine while the individuals will have to do so. Apparently, the individuals will be suffering more than the insurer or the company concerned. That's why, after taking a second look, we believe that the arrangement should be consistent. That's why we're going to move a CSA to say that if the insurer has breached the requirement for getting the IIA's approval before any appointment of controllers or directors, then there'll also be a daily fine for the continuing offense. So that's our response to the issues raised at the earlier meetings. And if members have further questions, we'll be more than happy to answer. Thank you. Any questions? Well, if you don't, then I have. Item D. You said that sometimes if you just make a phone call to get some papers, there is no need for you to produce documentary proof of your appointment and so on. But then sometimes if you make telephone inquiries, I do not quite agree with that approach. In particular, for the institution concerned, if you try to inquire about privacy issues or other details which might be confidential, unless I can ascertain that the phone number is indeed from a bank or a particular party, then I would not be providing the information just over the phone. So if the IIA were to take out any investigation, should you just be making a phone call to get the information? Because some of the information could be rather sensitive. So you said that you would be making a phone call to get the information. And if you ask about the personal particulars of any individuals, that would be sensitive. Well, Chairman, I might not have made myself entirely clear, because last time when we discussed the issue, whether it's the inspector or the investigator, in conducting any inspection or investigation, there is a legal requirement that the appointment letter should be produced. Because initially, the IIA would be appointing someone to be the inspector or investigator. And last time, during our discussion, we said that where there is an investigation, then the investigator will have to produce the copy of the direction or appointment before he can start the investigation and obtain information from the insurer. But then if it's an inspection, we do not have a similar provision. The original intention is that if it's just a routine inspection, then the inspector would only be providing the documentary proof upon request.
As I was saying, inspections are routine and may be done quite often, and it will be quite troublesome if every time they have to produce the certificate of appointment. That is why we do not require that to be done. However, they have to do that as soon as practicable if they are requested to do so. That is why there are different requirements under the provisions. In other words, I have the power to request them. Yes, you can ask an inspector to produce the certificate of appointment. So if I receive a call, I have the power to refuse to produce or let him know what is being asked. Well, this is what the law says. If they are requested to do so, they have to produce the certificate of appointment. Okay, that I understand. If there are no other questions, we can go back to clause-by-clause examination. Last time, we were on page 125 of the Chinese version of the marked up copy 41K, Division 3 Magistrates Warrants. Who will take us through that provision, please? Thank you, Chairman. We will continue with page 125, 41K. Sorry, the speaker's not coming through. Sorry. You talked about CSAs. Maybe I did not hear you clearly. What will be the direction of the amendments? We have said that we would move some CSAs because in the draft we say that if without the approval of the IIA, the insurer will only pay a fine, but the individuals, meaning directors or controllers, will also have to pay a continuing fine, which is calculated on a daily basis. We are going to move a CSA to provide for insurers paying the daily fine as well. In other words, that will be aligned with individuals. Yes, no problem, no problem. Now we are going to start with 41K. 41K will be looked at in a batch until 41O. This section has to do with magistrates' warrants to enter premises, and these premises may not be premises used for insurers' businesses. This is what is in 41K bracket 1, and then let us go to bracket 2 on page 126. The magistrate may issue a warrant authorizing a person mentioned in the warrant and other persons who may be necessary to assist in the execution of the warrant to enter the premises, if necessary, by force at any time within the period of 7 days beginning on the date of the warrant, and to search for, seize, and remove a record or document that the person mentioned in the warrant has reasonable cause to believe may be required. And then in bracket 4, if upon entering premises, the investigator or inspector can ask the person to produce certain matters which are believed to be required to be produced under section 41B or 41D. If there are no problems, let's go to page 127, bracket 5. An authorized person may, in relation to a record or document required to be produced under subsection 4, prohibit a person found on the premises from removing the record or document from the premises, erasing anything from, adding anything to, or otherwise altering anything in the record or document, or otherwise interfering in any way with, or causing or permitting any other person to interfere with the record or document. And they can also take any step that appears to be necessary for preserving the record or document, and then they of course have to produce the warrant for inspection. Bracket 7, Section 102 of the Criminal Procedure Ordinance will apply to property coming into possession of the authority. As for penalties, anyone without reasonable excuse fails to comply with the requirement or prohibition imposed on the person under subsection 4 or 5. Then in bracket 9, upon indictment, there could be a fine of $1 million and to imprisonment for 2 years, and on summary conviction to a fine at level 6 and to imprisonment for 6 months. If there are no questions, we can go to 41L. Removal of records and documents under Section 41K, that they could be kept for 6 months, and if there are any criminal proceedings or any proceedings under this ordinance, they could be kept for a longer period. If an authorized person removes a record or document, he must, as soon as practicable, after the removal, give a receipt. Any questions? If not, Division 4, miscellaneous. 41M, lien claimed on records or document. If the person in possession of the record or document required to produce claims a lien, the requirement will not be affected by the lien, and no fee is payable for the production. And the production is without prejudice to the lien. 41N, production of information in information systems, that the powers to require production of information will also apply to information systems, and these must be in a legible form. If a specified person has taken possession of a record or document, the specified person must permit a person who would be entitled to inspect that record to inspect it and make copies at all reasonable times, and reasonable conditions can be specified by the person. No questions? We can continue. Page 130. Division 5. Disciplinary actions. 41P. In respect of authorized insurers, the authority can take disciplinary actions. 41P bracket 1. In what circumstances disciplinary action can be taken? That the insurer is guilty of misconduct. At bracket 5, we'll explain what misconduct means. Or the insurer was guilty of misconduct. And C, the authority is of the opinion that 1, a person who holds the position of a director or controller of the insurer is not a fit and proper person to hold that position. And bracket 2, the powers that can be taken by the IIA: A, to revoke the authorization of the insurer; B, to suspend the authorization of the insurer; and C, to prohibit the insurer from applying to be authorized to carry on a class of insurance business; and D, to reprimand the insurer publicly or privately. And page 131, E, to order the authorized insurer to pay a pecuniary penalty, whichever is greater, $10 million, or 3 times the amount of the profit gained or loss avoided by the insurer as a result of the misconduct or of the conduct of the director, etc. Bracket 3. If the authority has exercised its power under subsection 1, it may disclose to the public details of its decision, the reasons for which the decision was made, and any material facts relating to the case. Bracket 4. The authority in forming an opinion for subsection 1C may, among other matters, take into account the present or past conduct of the person. As I said, misconduct is explained under bracket 5, and 5A, a contravention of a provision of this ordinance, and B, a contravention of a term or condition of an authorization granted under section 8, and C, a contravention of any other condition imposed on an authorized insurer, and D, an act or omission relating to the carrying on of a class of insurance business that in the eyes of the IIA will be detrimental or prejudicial to the interests of policyholders or the public. Mr. Sin Chung Kai, under bracket 3, if the authority has exercised its power under subsection 1, subsection 1 is quite clear. Those are the powers or disciplinary actions that could be taken. But under bracket 2, the following powers are specified for subsection 1. Does it mean that in order for 1 to be done, you need to have 2, and therefore under 3 you should include 2? Chairman, thank you for that question, Mr. Sin. If we look at 41P1, this is on page 130. It says the authority may exercise any of the powers specified in subsection 2 in respect of an authorized insurer. Therefore, bracket 1 would already include bracket 2 because the powers are in bracket 2. That is why in subsection 4 or bracket 3, we mention subsection 1. And this is because subsection 1 says powers can be exercised as specified in subsection 2. Well, let me look at 3. It said it may disclose to the public. You use the word may, but not must. Have you considered using the word must instead of may? I remember under SFO, in terms of penalties, the SFC can take disciplinary actions against the licensees, and the records would have to be disclosed on the relevant websites. When you use the word may, well, yes, meaning it is possible, but may is not the same as must. Okay, why do you use the word may? The policy intent is that, generally speaking, if there is a decision, it has to be disclosed. This is about transparency, and also so the industry will be able to have predictability. In other words, a certain contravention would attract a certain penalty. Why do we not use the word must but may? This is because we expect that in certain circumstances, the IIA may not think it appropriate to disclose all details. That is why we give some discretion to the IIA so that it can choose not to disclose details of certain specific cases, but then the policy intent is for details to be disclosed for the majority of cases. I'd like to ask about this word may. Who has the active stance? Is it the IIA or the person contravening the provisions? Well, the IIA. Well, if I am the person doing the contravention, I may say that for privacy's sake, I don't want details to be disclosed. But then no, the powers to disclose details remain with the IIA. Mr. Sin, any more questions? I don't know. Well, I myself don't have so much time to look into all the details. What about the SFC? Let me try to answer the question. Yes, we can hear you. With regard to insurers, the situation may not be totally the same as that of the SFC, because the SFC regulates licensees who are usually intermediaries. But if you look at insurers, they are not intermediaries. They are insurance companies. So in certain circumstances, whether details or any of the details at all should be disclosed, the authority will have to consider whether there will be any possibility of volatility in the market or financial instability. Cases would vary, and therefore you have to balance different considerations. as the Deputy Secretary was saying, we would like to have transparency. That's the policy intent. But at the same time, we'd like to leave discretion with the IIA as to how the disclosure should be done and to what extent, and also to avoid volatility. We're actually under the SFO. The word may is also used in the comparable provision, so there will be consistency in the regulation. I may not want to follow up now, but I cannot accept what the Commissioner said.
In fact, your reasoning was contradictory because you said that you were concerned that there might be financial instability. All right. If it's just an individual, how can he do something which would result in financial instability? But then for the insurers, they are all insurance companies. That's why, as to whether or not the insurer has committed any offences, whether or not there have been contraventions, and whether such details can be disclosed, and whether the disclosure might, for example, result in some insurance policies not being honoured and rumours being spread and so on. So indeed, that could destabilize the financial system. That's why, in this regard, we have to be very careful. And to what extent should the details be disclosed, and what are the possible implications and so on. I'm sure the authority will have to bear that in mind. Next, Chen Kin-po. I'm sure in the process, the insurers, I think that has given rise to a lot of misunderstanding. In fact, for the insurers, this is not an individual, but then can we just change it back to insurance companies? I don't know why. But then it's the time for us to change it back to insurance companies. Why do we use the term insurer, which might have an implication that is an individual rather than a company? So can you look into that again? My question on 41P under subsection 2, you said that you can revoke the authorization of the authorized insurer. All right, if it's been in operation for some time, then what is going to happen to the insurance policies under risk care? If you were to revoke the authorization, you don't need to set out everything here, but then if you were to revoke the authorization, you would also have to take into account the policies under risk care. We will have some subsequent provisions setting out the situation whereby an insurer has had its authorization revoked or suspended, so we can take it up later. But then in brief, when the authorization is revoked or suspended, the insurer will still have to discharge its duties, and the authority can also order the insurer to return the details of the policyholders to the individuals concerned, so as not to affect the interests of the policyholders. All right. We'll bear that in mind, and then by the time when we reach that section, we'll be able to revisit the issue. All right, move on, please. 132, 41Q, procedural requirements in respect of exercise of powers by the authority. So these are the procedures required of the authority. That includes that before exercising the power, the authority must first give the authorized insurer an opportunity to be heard, or else the authority must not exercise that power. And then under 41R, it says that before the authority announces the guidelines on imposing the pecuniary penalty, it must not exercise the power. And these guidelines are not part of the subsidiary legislation. 41S. It says that the authority, in upholding the interests of the policyholders, he can reach an agreement with the insurer under A, he can exercise a power that the authority may exercise in respect of the insurer under this part, and B, take an additional action that the authority considers appropriate in the circumstances. And subsection 2 says that the authority must also comply with the procedural requirement under 41Q unless the insurer agrees otherwise. And then 41T, order for payment of pecuniary penalty. Within 30 days of the imposition of the fine, the insurer will have to pay it, and the court of first instance may, on an application of the authority, register an order to pay the fine in the court. And subsection 5, it says that the pecuniary penalty paid to or recovered by the authority will have to go to the general revenue. And then 41U is in response to what Mr. Chen Kin-po said, and both U and 41U and V said that if the authorization of an authorized insurer is suspended, the insurer must, during the suspension period, continue to comply with the obligations under the ordinance. And without limiting the powers that can be exercised by the authority, the arrangements will not be affected by the suspension and so on, and also the powers and obligations would also not be affected. 41W says that if the authorized insurer's authorization has been revoked or suspended, then the authority may require the insurer to transfer to a policyholder of the insurer a copy of the records relating to the policyholder's assets and or affairs. Failing that, he could be subject to a fine of $200,000 and to an imprisonment of 2 years. Next, 136. Starting from page 136, that's from clause 42 to 49B. That's all the way up to 145. It's about the circumstances in which the insurer has become insolvent and so on. Under the new, both the old and new clauses would apply. What we're trying to do here is to update the terms. For example, the insurer has become the authorized insurer and so on. And also the authority has also come in. Next, page 137. Again, these are textual amendments. Next, 138 is about winding up of insurers. So this is just an updating of the terms. And then 139, again, these are textual updating. And then 140, 141. Next, page 142 and 143. Again, these are technical amendments. And then 144, again, just a textual amendment. And then 145, we have a triangular mark here, and working day is denoted here. In fact, under bracket 2 and bracket 3, it refers to authorized insurers, and under certain circumstances, within 3 working days, they will have to give notification or notice to the authority in writing. For example, where the assets have been taken over, or where there are legal proceedings require them to make a payment. So within 3 working days, notice will have to be given to the authority. So under this bracket, we try to define what's meant by a working day. In fact, in page 2, in the interpretation clause, we have deleted the definition there, and here we try to set out what's meant by working day here again. Please move on. Next, page 146. Starting from 50A to 50G, so they have to do with laws, and that's a trading center in London, so it's not an insurer, but then it provides a market for the collaboration of this business, and they've also got an office here. And like other countries, the original insurance ordinance or insurance companies ordinance would deal with Lloyd's separately, and we are proposing to deal with that similarly. So the amendments here are just updating an updating exercise. For example, under 146, these are the updating of terms and also the referencing of the clauses. Page 147, 50B, the original provision says that Lloyd's shall appoint a person as is authorized representative in Hong Kong. In other words, it has to have an authorized representative in Hong Kong. And then in the amendments on the next side, on the other side, earlier on, with regard to the controllers of insurers, the authorization of that, and also where there are contraventions, there would also be penalty clauses that would also apply to the Lloyd's representative here. And subsection 4 and 5, next to the triangular mark, it says that a reference in those sections to an insurer, to an authorized insurer, is a reference to Lloyd's, and also a reference in those sections to a controller is a reference to the authorized representative of Lloyd's. Under 50B, we have deleted clauses subsection 5 and 6. As we have explained, those are the appeal clauses for the financial secretary, and we have already got new clauses to deal with appeals. That's why we have deleted those clauses. Any questions? Next, page 148. These are textual amendments in the first few clauses, and then in the bottom part, with regard to 4 months, the original wording was 6 months, and now it's been changed to 4 months. With regard to the time limit, in fact, within the same provision concerning the submission of the annual financial report, for a 4 months period has been set, so that's consistent. All right. If there are no questions, then page 149, 50E. In fact, it also appears in the earlier version. Now we try to specify its part 10 is about insurance intermediaries, and that would also apply to Lloyd's. And where there is a reference to an insurer or authorized insurer, is also a reference to a member of Lloyd's. All right. Page 150, 50G is about part VA. It's about inspectors or investigators' powers. So these are new provisions, and also the disciplinary inquiries and so on. So that would also apply to Lloyd's or members of Lloyd's. So it says here that the provisions, except for section 41P2A, B, C, and 41U, 41V, and 41W, apply to one or more of the following as the context requires: Lloyd's, a member of Lloyd's, and also members of Lloyd's taken together who carry out insurance business in Hong Kong. If there are no questions, then next, page 151. In fact, we just deleted section 2 of the banking ordinance, because here it refers to an authorized institution. And then on page 7 of the marked up copy, we have already got an interpretation clause, and therefore there is no need for us to specify that is an authorized institution within the meaning of section 2 of the banking ordinance. Next, Chan Kim Po, on exemptions. All right, you've set out so many things here. So is that a historical legacy? Do we need to have so complicated things here? You talk about trade unions and so on. Is it still applicable? So have you looked into that? Do we still need to have that many exemptions? Yes, Commissioner, let me respond. In fact, for the exemptions, what Mr. Chen raised was reasonable. Indeed, there is a historical background to this, but then for individual provisions, for the exemptions there, we understand that there are institutions or parties engaging in such activities. As to whether or not we should review that further, and do we still need to have those exemptions in the future? In fact, under the amendment bill this time, we have not specifically conducted a review exercise, because in itself is already a very complicated piece of legislation, and for anything that we propose to change, the implications could be far-reaching, and that could also affect some organizations' operations. That's why, in the future, upon the setting up of the authority, it will be looking into all the individual provisions to decide if they have to be kept.
They would have to see whether there are still entities involved in such acts. From A to I, especially those in between cooperatives, trade unions, and particularly cooperatives, they conduct activities and provide welfare. If there are deaths or natural disasters, they would distribute such welfare to their members. They would distribute money to their members. And this is quite similar to taking out a policy and paying premium. If we make any changes here and take away the exemptions, we'll have to take another look at the possible impact there will be on such organizations, and whether such organizations should be included in this scope. Therefore, I wouldn't underestimate the scope of work to be done. That is why we are not reviewing each and every clause. We will leave it to the IIA, and it will have to look at each and every of these after every setup. Well, these organizations have been there for many years. They may not know that they will be included. Now they enjoy exemption. We know that they exist. But as to how many there are, well, since they are exempted, they do not have to declare to us what is being done. If we were to review each and every section or clause, I think a major exercise will have to be undertaken. I think the law as written is quite narrow, and there is a gray area. Right, maybe they don't know it, but they may be doing things that are similar to the taking out of an insurance policy. And in order that there will not be any inadvertent breaching of the insurance company's ordinance, they have been excluded 30 years ago when the ordinance was enacted. Well, I think the IIA has to be cautious about people who might abuse the loopholes. Okay, that will be recorded for the time being, that you have to be aware that there are loopholes. If there are no other questions, let's carry on. Page 152. Secrecy disclosure clauses. Under 53A, well, this has to do with the business of insurers. And we are talking about public officers, and also that there are secrecy provisions to be applied to such people. We have to update the ordinance to reflect that the new IA is an independent statutory body. And also, the information about intermediaries will also have to be regulated. On page 152, there are these amendments whereby members and also consultants and also other people at the IIA, if they have performed a function and if they come to the knowledge of certain matters, then these have to be kept secret. And it is not just about information relating to an insurer. So we are saying any knowledge that comes in the course of performing a function. So in short, that is the purpose of amendments made on page 152. Mr. Sin Chung Kai. I don't have a question. But when you say persons under A, IIA, and there is a list in the bill for the composition of the IIA, but under 4B and 4C, there are industry advisory committees and other committees to be established. The members may be IIA employees, but not every member will be an employee. Since you have got the list of members in the law, you can do either things. You don't tell the members anything that is secret, or you let them know, but then you ask them to keep everything secret. And in other words, are you going to include those under 4B and 4C? Commissioner, we are not there yet. We are on page 152, but that is under 1AAB on page 153. Under A person who is or has been appointed under the provision of this ordinance. The advisory boards, etc., will be included under 1AAB bracket A. Generally speaking, we believe the two consultative committees will advise on the business of the industry. But if through their appointment they get to know things listed here, they will be regulated by the secrecy or disclosure provisions. No more questions? Let's carry on. Page 153, the triangle. The Commissioner has already covered that. And then let us look at the square. This has to do... Sorry, can I please carry on? I'm not reacting so fast. 1AAB. The drafting is not the same. You have 1A and then 1AAB. This may be a drafting issue, but it may lead to other problems. Why don't you put 1AAB, ABC as EFG? Because on 152, are you saying bracket 1AAB should be subsumed under 1AA as EFG? This may be a drafting issue, but since you have drafted it a different way, does it mean you mean something different? Thank you, Chairman and Mr. Sin, for your question. Under 1AA, we talk about people within the insurance authority, the persons employed or authorized or advisors or managers. But under 1AAB, they may not be people within the IIA, but nevertheless, they would discharge their functions under the ordinance. You may see these things on two different pages, but in fact, the section continues. No other questions? Do you understand now? Well, I don't have other questions. But I have a comment. I, in a way, am still thinking out loud. But if you draft something like ABC under 1AAB, you seem to be quite encompassing in what you are trying to say. I think you are really targeting 4B, 4C. Do you get what I mean? Let me try to explain. Those who may easily be caught, well, I shouldn't say they would be caught easily, but under IIA later on, there may be committees which may come into information that has to be kept secret. However, the members themselves may not know. Of course, you can remind them there and then, but if you write something like this, or like 1AAB, I think you're really very encompassing and you are not specific enough. Okay, that's a comment. Will you insist on amending it? Well, I'm reminding them about this. I don't know whether they like to respond and whether they would look at other ordinances and the committees under those ordinances and whether the drafting should be more specific. These are drafting matters. The Commissioner or? Thank you, Chairman, and also the comment from Mr. Sin. We will reconsider this, and as Mr. Sin said, we will take reference from other ordinances. Okay, no more questions. Let's continue. Page 153, the letter half. The original subsection 3 says that subsection 1 shall not apply to the disclosure of information. And at the square, we update the situations where this will not apply. Under A, we have included the mention of licensed insurance intermediaries, because under the amendment bill, we also send information of licensed insurance intermediaries to the IIA. And then in AB, we say that if the purpose of disclosing information is to barristers or solicitor who act in their professional capacity or other professional advisors in order to seek their advice, then the disclosure provisions will not apply. Bracket AC is a new subsection. If the purpose of disclosing information is for an audit required under Section 5A or otherwise in connection with this, then the disclosure provisions will not apply. Page 154. Again, exemptions. Bracket CA, disclosure to the tribunal in connection with any proceedings. And then bracket CB, disclosure by a person in connection with any judicial or other proceedings to which the person is a party. And bracket CC, the disclosure is done in compliance with an order of a court or in compliance with a law or a requirement made under a law. Under these circumstances, the disclosure or secrecy provisions do not apply. Next, bracket E, the existing ordinance states that there could be disclosure to the financial secretary or inspector appointed by the financial secretary or a person holding an authorized statutory office. And in that circumstance, again, the secrecy provisions do not apply. We specify specified persons under EA. When we go to page 160, we will explain to members. But let me draw your attention to the fact that there will still be protection for the disclosure. On page 154, on the left-hand column, it is said that in the opinion of the insurance authority, it must be desirable or expedient that the information should be so disclosed in the interest of existing or potential policyholders or the public interest. And then still on 154, bracket EA on the right side, we were thinking of investigators getting information. So we have included this section to say that such information can be disclosed to the Financial Secretary, the Secretary for Justice, the Commissioner of Police, the Commissioner of the ICAC, and the Tribunal if the information is obtained by an investigator. Okay, page 155. Sorry, please wait. Mr. Sin Chung Kai. Disclosure to regulated bodies. Sorry, it's the turn of Mr. Ng Liang Sing first. Sorry. On EA that you just read out, four of the parties are named, but the last one you just mentioned the tribunal. If the tribunal is a unit and you don't specify the people, are you talking about anyone at any rank at the tribunal? Who will answer the question? Chairman, the tribunal means the appeal tribunal. But then there are many people at different ranks. We are talking about the Insurance Appeals Tribunal. The tribunal is headed by a presiding officer who is qualified to be a high court judge. And there are two other persons at the tribunal. And these two persons, stated in the law, will be appointed by the CE. They are a panel, and from the panel, two persons can be selected to form the tribunal together with the chairman.
So these persons have already been appointed by the CE to form the tribunal. In other words, you're referring just to a handful of people, so you have a presiding officer together with two members. But then if you have not specified that here, so you are saying that it would be confined to the several members of the tribunal, and even if the information is disclosed to them, it's okay. That's why you do not have to name the members, not like the other parties, like the FS and so on. So are you sure that the disclosure will not lead to any wrong disclosure? Well, it means that the authority staff, when they exercise their powers, they are not supposed to disclose the information to outside parties other than these parties specified here. Because in the course of the investigation, if a disciplinary action has been taken, then an appeal can be lodged by the relevant parties. So if a decision is taken, then the affected party can go to the IAT to lodge an appeal. And that being the case, we will have to specify that when we obtain information by exercising the power in the course of the investigation, we have to be able to disclose the information to the tribunal. And under the law, there are only 3 members, the chairman plus 2 members in the tribunal. I'm just trying to make sure that even if you do not specify the rank or the rank of the personnel of the tribunal, you are suggesting that the information would only be disclosed to a handful of people within the tribunal, and there is no possibility of the information being disclosed to the wrong parties. So all you need to do is to specify that the information will be disclosed to the tribunal, and you think that is adequate? Yes. All right. For the exemptions and also the disclosure, are there any circumstances whereby you will have to disclose the information to other regulators? Who is to answer? Well, in later provisions, we'll set out which institutions or organizations can receive the information. All right, page 156. So it's where Mr. Sin was interested in. As for the other regulators, in fact, under 3B on the right-hand side, or the left-hand side, we refer to the Authorized Statutory Office. It refers to the Monetary Authority, the SFC, the Mandatory Provident Fund Schemes Authority, and also the Financial Reporting Council. And then page 157, the Legislative Council may by resolution amend subsection 3B by adding or deleting the authorized statutory officers defined therein. And it also says that the disclosure of information to specified persons, including the authorized statutory officers, and also we have the Chief Executive, the Financial Secretary, the Secretary for Justice, and also the Secretary for Justice under the company's ordinance can also appoint investigators. So the information can also disclose to him. And also F, any public officers authorized by the Financial Secretary can also receive the information. And on page 157, 3 capital letter D bracket A says that, well, 3B would not apply under certain circumstances, and then 3D restricts the circumstances where the information is disclosed to the following parties, and they are prohibited from further disclosing the information to other parties. And then in the newly added 3DA, it also talks about the further limitation of the spread of the information. It would not apply to the following situation. A, the information has been made available to the public, and B, the disclosure is for seeking advice from a counsel or a solicitor, and C, the disclosure is in connection with any judicial or other proceedings, and D, the disclosure is in compliance with an order of a court or in compliance with a law or a requirement made under a law. Next, 3F and 3G. 3 capital letter F inserts a power for the authority to disclose information in the by imposing certain conditions, and the monetary authority he may impose certain conditions. And 3G, the monetary authority may attach a condition to a disclosure of information made by the monetary authority under this power or under this section, and the person and the authority has also been given that power. Next, page 158, starting from 3I, 3 capital letter I on the right hand side, it talks about the prohibition to disclose the information does not affect the operation of the Ombudsman Ordinance and also the Personal Data Privacy Ordinance. Next, triangle subsection 7 is a technical amendment. In this section, a reference to this ordinance means this ordinance as amended from time to time. Sorry, speaker is not coming through. Administration, can you explain? A member is of the view that subsection 7 is superfluous. Thank you, Chairman. Thank you, Mr. Sin, for your question. The reason why we have to have this clause here, if it's not put in here, because in this section, many references have been made to this ordinance, and if there is no such reference here, then under the Interpretation and General Clauses Ordinance, this would apply. But then for this particular section, it would apply to the existing insurance authority or the existing Commission of Insurance, and in the future it would apply to the Independent Insurance Authority. That's why we have to specify that when a reference is made to this ordinance, it would also mean this ordinance as amended from time to time, because at different stages the provisions might have changed, but then they will still apply. So we are not just referring to the new provisions under the amendment ordinance, because we're talking about provisions at different times of enactment. But some of these are just common sense issues, because any ordinance would be subject to amendment from time to time by this Council, and of course the prevailing ordinance will apply. So objectively speaking, without this subsection, I think is superfluous, is gilding the lily. So you're stating the obvious. Well, it doesn't harm, but then even without this subsection, will there be adverse consequences? Would there be any consequence at all? Will it affect the operation of the future ordinance? Yes, because 3 years down the road, the ordinance might not exactly be the same as it now stands, but then 3 years later, when we look at the ordinance, we would be looking at the provisions of the prevailing ordinance. But then for the ordinance that is in force now, we will have to look at what happened in the past, and also how the law was worded at that time. So we will have to specify that when a reference is made to this ordinance, it would mean the ordinance as amended from time to time, because 3 years later we might be looking at the ordinance as it now or as it stood 3 years ago. So we will need to have this provision. So it's not superfluous at all. Next, page 159 and also 160 is about 53B is about disclosure of information. The original 53B allows the insurance authority to disclose information to an authority in a place outside Hong Kong where it's related to the insurers. And then on page 160, we have inserted a new 1B to expand the scope of the existing provision so that the authority will be empowered to disclose the information of licensed insurance intermediary to outside regulators. And if you look at the protection afforded under subsection 2 and 3 in on the 2 pages, you'll be able to see that the authority shall not provide information relating to the affairs of any individual policyholder of an insurer. Are there similar provisions in the laws in other jurisdictions? Thank you, Chairman. Generally speaking, our counterparts overseas would have similar legislation. In fact, that's what is required of the IAIS, the International Association of Insurance Supervisors. We have also signed a multilateral collaboration agreement under the IAIS. Not all parties are allowed to sign, so any insurance authority would like to sign that agreement, we will need to have all the member states to look at whether or not all the parties concerned have the secrecy provisions before they would be allowed to sign such an agreement. And other than the multi-party agreement, we have also signed bilateral agreement with different insurance authorities elsewhere. Before we sign such agreement, we would also have to make sure that they also have reciprocal secrecy provisions before we would sign such an agreement. And if we indeed have to solicit the disclosure of information from the other parties, we will also have to refer to the relevant collaboration agreement in order to meet the secrecy provisions before we can disclose or submit the information to the other side. So members can rest assured that amongst the insurance supervisors, the disclosure requirement is very stringent. I'd like to follow up on a point made by Mr. Sin Chong Kai. Just now you referred to 53A, bracket 7, that is on page 158. It's a newly added clause. But then 53A, it's been there since 1995. So when we look at the amendment bill, do we need to have subsection 7? And then during the past 10-20 years, we did not have that need. And which parts of the existing amendment ordinance would require subsection 7? Thank you, Mr. Leong, for your question. In fact, the reason why we need to have subsection 7 is about 53A, because we're going to set up the new IIA, but then the provision would cover a situation whereby after the IIA has been set up, and then for any employees or representatives of the former Commission of Insurance, so for the former commissioners and so on, they would not be discharging any further duties upon the setup of the IIA, but then in the provision, they will have to be covered. That's why we need to have subsection 7 in order to ensure that these provisions will continue to apply. Chairman. In the other parts of this bill, do we have any provision similar to that here in subsection 7? And if yes, can you refer us to those parts? Thank you, Chairman. Thank you, Mr. Leong, for your question. In fact, about this secrecy provision, only under this would we need to cover the earlier commissioners, and so on. That's why we have to have a reference to previous ordinances. But then once the IIA is set up, we're going to have a new system. That's why we only need to have subsection 7 here in in clause 53. It's not needed in other parts. Thank you. Next, page 161. About disclosure of information to other supervisory bodies elsewhere. You talk about supervisory bodies. And just now, you talk about multilateral agreements, but then you would be limiting that to certain restricted authorities. For example, on the mainland, they have many authorities. So for the insurance authority on the mainland, he might have signed agreements with other international jurisdictions. So when it comes to the supervisory bodies, you should narrow the scope. Yes, under A, you have referred to that already.
But the authority can be anyone. And you said, you talked about those who have signed bilateral, multilateral, or international conventions with you. And it seems how you draft it is much wider. Who can take the question? Under 53B, the authority would mainly be the IA. So you have A, small 1. We have equivalent authority, or 53A3. Those duties would relate to securities, banking, and other authorities. Because in certain places, they do not have an insurance authority, but they have a super regulator. These two taken together would mainly mean comparable authorities to the IIA. That is why we have A small 1 and A small 2. And these will not be those that you mentioned. Those you mentioned would relate more to public interest. But here, we are really talking about corresponding authorities to the IA. Thank you for that answer. But still not the same. I think there are the functions to be exercised, but they have not signed any bilateral or multilateral treaties with you. Well, no, these will not be mentioned. But then, under the IIA, please look at B, 1, 2, and 3. Since between A and B, you have the word and therefore, when the other party requires disclosure of information, they will have to satisfy B, 1, 2, 3. B1 says that the authority is subject to adequate secrecy provisions. And generally speaking, if we have signed a memorandum for cooperation, in fact, before signing, we would have already looked at the secrecy provisions. No, sorry, I'm really digging very deep into it, but I'm sincere in asking these questions. My knowledge is limited. If the IA in the mainland asks you for information, they will have the provisions. However, when you ask them for information, they may not give it to you. And I'm asking whether this is a corresponding kind of cooperation. You look at their laws, there will be secrecy provisions, so you give them the information. What about reciprocating the arrangement? Well, a short answer is, sorry, Mr. Sin, reciprocity might not have only to do with the mainland. What about the US? Fine, okay, I can correct myself. The premise on which you give them the information is that they would do the same to you. Well, if we have signed a memorandum for cooperation, and under B1, we would have to satisfy ourselves that there are adequate secrecy provisions. Our experience over the last 30 years tells us that there could be such reciprocal requests. I have read these provisions. Even under 1, 2, and 3, it doesn't say that the request must be reciprocated. Well, this is a requirement we place upon ourselves. When we request information from the other party will also look whether we have adequate secrecy provisions. And it will be quite complicated if we look at each case when it comes up. But usually we would sign the memorandum for cooperation first, and if there is such a memorandum, then there will be reciprocity. However, if there is no memorandum for cooperation signed, then we can't say for sure. They may not be happy to give us information because they do not know our secrecy provisions. Since every jurisdiction has its own provisions, and if there is not such a memorandum signed, it will be rather difficult. We don't give information to other regulators lightly. But if you have signed bilateral arrangements, well, I understand we have other ordinances providing for the exchange of financial information. But how can you evolve the drafting to such a stage that, well, sometimes it's not an exchange? I remember when we studied taxation laws, you would limit it only to parties which have signed bilateral or multilateral memoranda with you. Well, basically, yes, if there is a memorandum signed, there will be a reciprocity. If they require us to, we will give it to them, and the same applies to us. But if there is no signing of memorandum, we cannot say for sure that this can be done. Well, in fact, I'm pushing a point here. If there is no signing of memorandum, no reciprocity, then you should not provide the information. Sorry, I did not hear you. Even if you can comply with A1 and A2, in other words, you would have complied with bracket 1, small a and small b. However, there is no signing of bilateral or multilateral memoranda. There should not be any exchange of information. If I remember correctly, that is how the exchange of taxation information is drafted. Chairman, I will not talk about the mainland, but the U.S. may say the information is confidential, so it will not be disclosed to you. If there is no reciprocity, then should we still disclose the information? I'm sure about the exchange of taxation information, there must be reciprocity. There must be bilateral or multilateral arrangements made. First, we have to protect Hong Kong people's interests. Overseas statutory bodies may come to you for information, and they satisfy A and B, and we immediately disclose the information. Is that the case? As I said, if there is a bilateral or multilateral memorandum for cooperation, then things are simple and we are certain. But Mr. Sin is saying if there is no signing of such memorandum, we must not disclose the information. Well, then it depends. In fact, we need to know what kind of information they are talking about. Is it about the robustness of a certain company? Would that also benefit ourselves? And if we would require information from the other party, then we might be doing it because it's related to our enforcement work. So I cannot give you a broad brush answer. But if there is the signing of a memorandum, then the situation would be much more desirable because there will be certainty and we would have looked at each other's secrecy provisions. And since we have signed the multilateral agreement, a few dozen countries have also signed that agreement, and we have also signed bilateral agreements with dozens of other places. And basically, with places where there are multinational companies, we have already got the arrangement, so there is no big problem. As you're saying, we should not disclose any information if there is no agreement, but that might not necessarily be the case. It all depends. It depends whether we will be helped to discharge our functions at the IIA and without breaching the interests of existing or potential policyholders or the public interest. B3 will limit us as to what can be done. We must consider all these points before there can be disclosure. This is a statutory duty of the IIA. If it is not satisfied that B1, 2, 3 are complied with, it should not do anything. But we shouldn't say that we must not disclose anything if there is no agreement signed. I think we should look at each case on its individual merit and whether it is in the public interest and whether the other party has adequate secrecy provisions. I understand that you are just trying to change the name of the IA to IIA, and these are existing provisions. But still, I like to ask these questions. I know this is not a bill to change the policy, but I hope my memory serves me well. Talking about the exchange of taxation information, how should I put it? When people ask our controlling authority for information, of course we consider all these things because we are assisting them. We are not assisting ourselves. If we are doing investigation and we ask the other party for information, then that's different. But if you look at the exchange of taxation information, well, I hope my memory serves me well, but pardon me if I have remembered anything wrongly. We limit what the IRD can do with our law. We say that without bilateral or multilateral agreements, there should not be any disclosure, but you are not subject to the same kind of restriction. Well, but the situation is different. The disclosure mentioned here mainly has to do with business information of insurers or the appropriateness of the personnel. The information has nothing to do with policy holders. And we are subject to B2 and B3. In other words, it must not be contrary to the interests of existing or potential policyholders or the public interest. And the information disclosed is for the sake of doing supervisory work. It is not about the private information of any individual. Are your doubts allayed? I don't want to continue to argue here. Well, this should be for the government to say it, but let me try. Under B, it says subject to subsection 1 or without limiting the generality of subsection 1. And also 1B3, it says may. In other words, you don't have to include it. You may include it. In other words, I think the provision allows the IIA to have flexibility. Sometimes there might not be the signing of bilateral or multilateral agreements for cooperation, but if there are criminal activities committed, even if there is no signing of bilateral or multilateral agreements for cooperation or exchange of information, and if indeed there is a criminal act across boundaries, and if there has to be judicial enforcement, then perhaps the IIA can provide information about a Hong Kong insurer to the other party. I think the IIA will act within limits. It will not disclose just anything. However, without this provision, it will not be proper. With this provision, the IIA will know that it has to operate within limits. Well, I think what Mr. Sin is talking about is the personal information on taxation about certain individuals. May I ask you to turn to page 160, bracket 2, that it shall not provide any information relating to the affairs of any individual policy holder. You can only provide information of an insurer or the controller and the business operation of insurers. Still, even if it's the information of insurers, we must satisfy 1A and B before we can do it. The IIA has the duty to give this comprehensive consideration. But reality is our major counterparties have all signed bilateral and multilateral memorandum for cooperation with us. So operationally, we are well provided for. Okay, well, this will be recorded. If there are no other questions, we can carry on.
Next. Sorry, legal advisor, you have something to add? Yes, thank you, Chairman. Just a minor drafting point. On page 161, under 53 capital letter C2, reference is made to subsection 1B, and there are some changes, and therefore they will have to add one capital letter A and B. Well, under the existing provision, reference is only made to subsection 1 small letter b, and once you add in one capital letter A, should they also refer to one capital letter A, subsection A and B? Would it be more appropriate? We'll go back and think about it to see if we need to make that reference more specific. So please think about it, because the reference is to small letter A or B, or are you referring to one capital letter A and one capital letter B? 53C now. Under the existing 53 capital letter C, it says that the insurer would have to permit the insurance supervisory body or authority of a place outside Hong Kong to examine its books and so on. And then under one capital letter A and one capital letter B, the two new subsections is to expand the scope of application for this provision. It says that a licensed insurance agency or a licensed insurance broker company or their parent company, if they have set up a parent company outside Hong Kong, then the insurance supervisory authority of a place outside Hong Kong, if it has got approval to look at its books, then the insurance company or its agency will have to allow the supervisory authority to examine its books, accounts, and transactions in Hong Kong. And under the existing 53 capital letter C, subsection 2, the safeguards remain unchanged. In other words, the examination concerned should be carried out in the interest of existing or potential policyholders or in the public interest, or else the insurance authority would not be giving approval. Sorry, speaker's not coming through. Please raise your hand before you speak, or else I won't know that you like to ask questions. I would have thought that you're just speaking to yourself. Yes, Sin Chung Kai, Chairman. You're actually introducing overseas supervisory authorities by allowing them to exercise their powers in Hong Kong. I didn't get it quite clear. So are you saying that we are allowing overseas authorities to enforce the law here in Hong Kong, but then they are examining the books and accounts and transactions in Hong Kong? As there are some companies which have subsidiaries or branch offices in Hong Kong, that's why that would also involve the overseas supervisory authorities, because they might need to take a look at the operation of these insurers' local branches and so on. But of course, they will have to get our approval before they can do it. In other words, the future authority will be giving the approval. That's a safeguard, and if we feel that that would not be in the interest of policyholders, or if it's not appropriate, then we can decide not to give the approval. So there is a checks and balance here. I don't quite understand it. Okay, if the same authority or organization, I mean, if the insurer just have an office here in Hong Kong, and if I need to look into the situation in the branch office, then it's within the same company. So what role can be played by the insurance authority? But then if it's in Hong Kong, even if it's just a branch office, still is an authorized insurer. So for certain transactions in Hong Kong or certain policies in Hong Kong, the supervisory authority might need to conduct a field examination. But then, as I said, we will have to comply with subsection 2. At present, such arrangements can already be made. Yes, Mr. Sin? I'd like to follow up on this. So it's similar to the earlier arrangement. Okay, I'm in Hong Kong. Do I have the power to go overseas to look at their books? If there is a need, I would contact the relevant supervisory authorities in that jurisdiction to make the request. Again, if it's the branch office of a Hong Kong company, then I might need to conduct a site inspection, and I would need to make that request. That's why whenever such a request is received, we will have to look at whether or not it's justified. That's why we have subsection 2. So we don't necessarily have to give the approval. I'm not entirely comfortable with this. My understanding is that it's not about the parent company supervising its Hong Kong branch. You are talking about the insurance supervisory authority of a place outside Hong Kong. So it's like the insurance authority elsewhere, which would like to check the information of an insurer in Hong Kong. So that's what one capital A and one capital B are all about. Is that right? Any questions? If not, then move on. Next, pages 162 and 163. So it's about 53 capital D and capital E. So it's about prescribed persons, and earlier on page 4, we have already given an interpretation for prescribed persons. We're referring to accountants, actuaries, and chartered accountants or auditors. And here is the provision about their submitting of reports, and this is a clause to enable them to submit reports. And given the new system, we have added the clause saying that the information might not necessarily have to do with the following persons, i.e. an authorized insurer or a former insurer, because under the new system, we would cover licensed insurance broker company. That's why we have got this updated provision. Page 163. The prescribed persons to send report directly to the IA, and the change here is the change in wording, and the same applies to 164. Page 165, a newly added provision saying that the auditor of the insurer, in fact, once he is aware that the broker has not complied with the specified requirements, then he can submit a report to the IIA. if there are no questions, then page 167. Starting from 167 is 55A. Well, 166 is a continuation of 53F. So these are the specified or prescribed circumstances. And then 167 is 55A to 63. So all the way up to 175. These are supplementary and transitional clauses. And in parts 13 and 14, they will be set out again. And by the time when we reach that, we will be explaining in greater detail to members. So that leads us all the way up to 175. So 167 to 175, right? So these provisions will appear again in parts 13 and 14 in the future, and we'll be explaining in greater detail then. Now, page 176 is a new part. That's about insurance intermediaries. It's about the licensing system for intermediaries. Earlier on, under 3A, we have already explained that we have defined regulated activities, and by that, we say that for intermediaries engaging in regulated activities, they will have to be subject to certain regulation, and we are explaining the licensing system, including the type of license here, and also the licensing requirements and so on. And it says that the authority will be able to have powers to investigate the intermediaries and so on. And we have also repealed some clauses here. Starting from 64 capital F on page 176, these are the interpretation clauses. For controller, we set out that in different business entities, certain insurance intermediaries can be defined. For example, as far as the sole proprietorship is concerned, it means an individual who ultimately owns or controls the carrying on of regulated activities by the sole proprietorship, or if the sole proprietor is acting on behalf of another person and so on, and also if the partnership is entitled to or controls no less than 15% of the shares, or is able to control no less than 15% of the voting rights in the partnerships in the paid-up capital. Mr. Sin? Well, for 15%, why 15%? Why not 20 then? Or 25? So, do you have any reference for this? Commissioner or the Deputy Secretary? Why 15% in terms of the voting rights? Well, in some ordinances, for example, the broadcasting ordinance about the controlling share, we also have this 15% threshold. What about companies ordinance? We need to go back and check. You must have a policy about this. Why 15%? Why not 25%? I'd like to see if there is any justification for this 15% threshold. Chairman, we have made reference to similar pieces of legislation, so we can provide the information later. But then, as far as I can recall, for example, under the broadcasting ordinance about the shareholding, well, 15% was also used as the threshold. So please jot that down. Maybe next time you can provide a written reply. Please go back and check. So in other ordinances, do you have similar arrangements? So is that the basis for your coming up with this 15% threshold here? Please move on. Next, page 177 is about the interpretation of license. Well, under our regulatory regime, there are 5 types of licenses for intermediaries. First, we have the licensed insurance agency, and then the licensed individual insurance agent, and then we have the license for the agency, and then the license for the individuals. So we do have individual insurance agents, And then we also have licensed technical representative agent. These individuals are working for the insurer, and also we have the licensed insurance broker company, referring to an agent or broker working in a particular insurer. We have actually borrowed the existing provisions with regard to the registration of these intermediaries. If there are no questions, move on. Next, 64 capital G, capital letter G on page 178 is about restrictions on carrying on regulated activities. 64G provides that other than licensed insurance intermediaries, other than those 5 categories of persons holding the license, a person must not carry on a regulated activity in the course of the person's business or employment or for a reward.
The other provisions also explain the policy intent, and then penalties without any excuse. If people contravene subsections 1 or 2, on conviction on indictment, a fine of $1 million and imprisonment for 2 years, and in the case of a continuing offense, to a further fine of $20,000 for each day during which the offense continues. Or on summary conviction, to a fine at level 6 and to imprisonment for 6 months, and in the case of a continuing offense, to a further fine of $2,000. Bracket 5. This section is subject to section 121. When we come to 121, we'll explain to members in more detail. Section 121 provides for exemptions. Say if a lawyer provides legal advice to clients, well, okay, we can wait till we come to section 121. Section 121 provides for exemptions. Okay, we'll leave it to the time when we come to 121. Mr. Sin Chung Kai has a question. 64G. 1 or 2. A person must not carry on a regulated activity in the course of his business or for reward. I'd like to ask whether there is any regulation of the employer. Now, if the employee doesn't have a license and the employer asks him to be a broker, then the employee will be guilty. But what if an employer who involves in insurance business without a license? Here it says a person, so it is not just the employee. Well, yes, that I understand. It says a person. However, in the course of the person's business, if I'm an employee, the penalty will be on me, not the employer. Or do you also penalize the employer? The mic should be switched on for the DS. Here, when it mentions a person, according to Cap 1, Interpretation and General Clauses Ordinance, it includes companies. In other words, this will include individuals or companies. The chairman says it includes a natural person. Okay, I'll ask a further question. If a person carries on a regulated activity without a license, then he breaks the law. But if it is a licensed company which instructs a person without a license to operate insurance business, well, if a person doesn't have a license, then why would he be involved in the business? Because it's directed or instructed by the boss. Well, if I don't have a license, if I don't have a driver's license, for example, how can you ask me to drive a car? Let me put it this way, Chairman. Mr. Sin, if an employee operates without a license, he commits a criminal act. But if he is instructed to do it, then that person would be aiding and abetting the other person, said the chairman. And according to the crimes ordinance, that person who instructs the other will be penalized as well. But then you don't talk about a licensed company instructing people without a license to do something. Well, that is not necessary, because according to the common law or the crimes ordinance, we can already cover the scenario you painted. Mr. Alan Leong, can you assist us? Well, he can give you the advice, but he will not be paid. Is it that the other person will be guilty of aiding and abetting? All right, let's continue. 64H on page 180. Application of Section 64 in relation to marketing insurance services outside Hong Kong. If a person actively markets to the public from a place outside Hong Kong, then under 64G2, the person will be regarded as holding out that the person is carrying on a regulated activity. So he will be regulated by the license. Ms. Darley, we are on page 181. We are doing clause-by-clause examination according to the Chinese version. Can we carry on? Yes, page 181. In the existing ordinance, section 65, it states restrictions on authorized insurers and licensed insurance agency, so that no person should be at the same time appointed as a licensed insurance agency or licensed individual insurance agent in carrying out a regulated activity. In the new 64 capital I and until K, and also in 64N, we are replacing the original requirement. Actually, the requirement is the same. It's just that we are updating it and we are giving a more detailed interpretation. Under 64I, we talk about authorized insurers and licensed insurance agency. We state that they should not exceed what the IIA states in sublet, and that is the maximum number of authorized insurers. At present, licensed insurance agents cannot be appointed by more than 4 insurers. And also, there should not be more than 2 who are involved in a long-term business. And therefore, 64I just gives expression to the present situation. And the penalties are anyone who breaches subsection 1, in other words, that the maximum number of authorized insurers being exceeded, then there could be a fine of at level 6. And with regard to authorized insurers who breach the same subsection, then there could be a fine of $1 million on indictment and imprisonment for 2 years, and on summary conviction to a fine at level 6. 64J and 64K are new. They replace one provision in the existing ordinance. And it reflects that under the new system, the restrictions are therefore authorized insurers and licensed insurance agencies. And in simple terms, under 64J, a proprietor or a partner of a licensed insurance agency, or a director or an employee of a licensed insurance agency who deals with any matter that relates to a regulated activity of the agency. And such people must not be a proprietor or a partner of another licensed insurance agency, a licensed individual insurance agent, a licensed technical representative agent of another licensed insurance agency, a licensed technical representative broker, a director or an employee of another licensed agency who deals with any matter that relates to a regulated activity of that other agency, and lastly, a director or an employee of a licensed insurance broker company who deals with any matter that relates to a regulated activity of that company. And the penalty is a fine at level 6 and imprisonment for 6 months. 64K. Just a minute. Mr. Sin. Are you saying that there should only be one person, one company in simple terms? Is this what you are providing for? One person, one company? Well, not exactly. If you are a proprietor or partner of a licensed insurance agency, then of course you must not be the proprietor or a partner of another licensed insurance agency. However, if you are a director, if you're just a director or investor or shareholder, then yes, but you must not deal with the regulated activities of that agency. In other words, he cannot directly take part in the regulated activities. If it is just investment, it is allowed. But if, on the contrary, he directs an employee to a client, then that will not be allowed because he will be taking part in the regulated activities of another agency. Yes, I understand. Commissioner, you mentioned directors of a board. But that is, in fact, the policy-making body of the company. It's just that they are not the frontline employees or the management of the company. Is that possible? It is okay if he is a director, but he can only deal in the internal affairs of the company, like recruitment. If it is about the sale policies or regulated activities, then it is not possible. So if it is just administrative, it will be allowed. Yes, if it is about the sales policy, then it is not allowed. Well, directors usually will come into contact with such matters. Chairman, you are the director of many companies. Another director may ask questions. Does it mean that that director has to recuse himself? Yes, he has to. But it's very difficult for you to regulate this. I can understand if it's a shareholder. If I'm just a shareholder and I buy the shares of a company which are going up in value, then I understand. But if you don't even regulate directors, well, actually they regulate managers. Of course, it is not possible for managers to be exempted. But directors will be limited to handling the internal affairs of the company. If it is about renting premises, recruiting personnel, then yes. But if it is about any regulated activity at all, then there will be a conflict with the original agency. So he cannot deal in the regulated activities of two agencies at the same time. Well, I think we can't understand how you are going to do your supervision. Let me ask about international standards. These are not international standards. So are you talking about one person, one company? Do you get what I mean? In other words, if I am in control of one company, then I should not control another company. However, if you also allow me to control certain activities of another company, why don't you just go for a clearer approach? Well, let me put it this way. We understand that the industry has some worries. People can be shareholders and directors. However, we think there should not be any conflict of roles. So you can say this is a compromise. You can only do certain things, but not everything. If, say, it is a directors' meeting, there will be proper records. But if they falsify the records, it will be a criminal contravention. So this is clear. No, I'd like to know how overseas jurisdictions do it, and how do you expect that you can enforce these provisions? We can give the information to you later. When we make laws, we must be mindful of the enforcement aspect. We should not make laws that cannot be enforced. to the policyholders, we like to protect their interest. We don't want the proprietors or partners to belong to two companies at the same time. But how do you expect to do the enforcement? You are saying people should not be directors of two companies. As Mr. Sin was saying, it should be one person, one company. That would be clear and specific. But you are saying both yes and no. So how do you expect that you can do the enforcement or supervision? I think that's the biggest problem. Well, we can wait till later to resolve this issue. Well, maybe we can give a written response in detail. We can let you know our considerations. Okay, that's the almost the end of the meeting because it's time. But the next meeting will be held on the 9th of March, Monday at 8:30. And also the 24th of March. I'd like to thank everybody for attending the meeting. So we are up to page 182, 64K. The meeting on the 24th will be held at 10:45. Thank you.